Good morning and welcome to our webinar, Reasonable Accommodations in the Workplace. My name is Robin Coker. I'm the Director of Communications at Disability Rights Florida. I'm a white woman with blonde hair, wearing glasses and a peach-colored shirt. On the screen, we have a PowerPoint slide that has a white background, purple lettering, and the DRF logo. The speaker for today's webinar is Allison Klein. She's the Senior Advocate-Investigator for the Client Assistance Program at Disability Rights Florida. First, we're going to review the accessibility features for this webinar. Our webinar includes closed captions and American Sign Language. Closed captions are available at the bottom of your screen by using the button that says CC. In the chat, there is a link to view the external caption. You can click on that link and have your captions appear in a separate window. We have two American Sign Language interpreters today. They are spotlighted on your screen and should be visible at all times. If you cannot see them, make sure your participants setting shows all video participants. If you have questions during the webinar, please submit them in the Q&A. The Q&A button is at the bottom of your screen. You can also send questions to the email address webinar@disabilityrightsflorida.org, and we will answer them at the end of the presentation. As a caution, please don't put personal information in the Q&A. Lastly, this webinar will be recorded and posted on our website and YouTube channel. Okay, now that the housekeeping is complete, I'll pass things over to our speaker, Allison, who will begin by providing a brief overview of Disability Rights Florida and the agenda for today's webinar.
Okay, can you hear me now?
Yes, we can.
Okay, great. Sorry about that. So thank you, Robin, and thank you all for being here with me today. I will first describe myself. I am a white woman with long, blondish curly hair, blue eyes, and black rimmed glasses, and I am at my desk at my home office with a blurred background. Disability Rights Florida is a federally mandated protection and advocacy, or P&A, organization, which means we are authorized and funded by several government agencies to protect the rights of persons with disabilities. These agencies include the Administration for Children and Families, Substance Abuse and Mental Health Services Administration, Rehabilitation Services Administration, Health Resources and Services Administration, and the Social Security Administration. Disability Rights Florida uses this funding to investigate, monitor, advocate, litigate, and educate on behalf of individuals with disabilities, ensuring their rights are protected and they can fully participate in society. Disability Rights Florida is also a part of the Nationally Designated Protection and Advocacy System, National Disability Rights Network, or NDRN. Collectively, the P&A and CAP, which is the Client Assistance Program, these networks, they consist of the largest provider of legally based advocacy services to people with disabilities in the United States. Disability Rights Florida existed since 1977 under the Executive Office of the Governor and became a private not-for-profit in 1987. There is a P&A in every state and territory. In Florida, we have 4 offices in Tallahassee, Tampa, Gainesville, and Fort Lauderdale, as well as telecommuters throughout the state. Our mission: Disability Rights Florida advocates, educates, investigates, and litigates to protect and advance the rights, dignity, equal opportunities, self-determination, and choices for all people with disabilities. Today, we were going to talk about what are reasonable accommodations, how to make requests for reasonable accommodations, and how to work within the interactive process. As Robin said, we can't advise on specific cases today, so please don't put personal information into the chat. Please contact our intake department if you want to request individual assistance. Contact information will be provided at the end. This is the beginning of employment accommodations, and on the slide is a blurred picture on the screen that looks like two people shaking hands in a workplace setting. What are reasonable accommodations? Reasonable accommodations are adjustments or modifications that enable people with disabilities to perform the essential functions of a job efficiently and productively. And I believe Keith has pulled up our first poll. Are you able to see the poll?
Yes, we could see it.
Okay, great. So it says, one, have you ever requested a reasonable accommodation? And your choices are yes, no, or what is a reasonable accommodation? So if you could take just a second to put your anonymous voting in there, that would be great. Okay, can we close the poll and see what the results are? Okay, great. So we have 63% said that yes, they have requested a reasonable accommodation. And no one asked what is a reasonable accommodation. So that's great. Thank you so much. We can close that out. So yes, reasonable accommodations are adjustments or modifications that enable people with disabilities to perform the essential functions of a job efficiently and productively. Accommodations vary depending on the nature of the job and the needs of the individual applicant or employee. So not all people with disabilities or even all people with the same disability will require the same accommodation or any accommodation. Furthermore, research by the Job Accommodation Network, or JAN, indicates that more than half of all accommodations cost nothing at all. Here are some examples of reasonable accommodations. Um, Job restructuring, such as altering when and or how an essential function of a job is performed, or reallocating marginal job functions that an employee is unable to perform because of a disability. For example, I had a client with a visual impairment, and the job description stated that they must have a valid driver's license as they used golf carts on the work campus to get from building to building. My client didn't drive, and we worked with the employer to allow them to ride with another employee. Driving was a marginal task, not an essential task, so it was removed from the job requirements. Modifying work schedules can allow an employee with a disability to attend to matters related to treating the disability, such as medical appointments or medication schedules. Acquiring or modifying equipment or devices, such as adjusting a desk height to accommodate an employee who uses a wheelchair, or providing an employee who has quadriplegia with a mouth stick device to type out on a computer. Adjusting or modifying tests and training materials. For example, providing materials in alternative formats. It could be Braille, it could be audio recordings or large print. Reassigning an employee with a disability to a vacant position for which he or she is qualified when no longer able to perform the essential functions of the current job with or without reasonable accommodations. Reassignment is usually an option later in the interactive process unless the employee requests it. And providing assistive technology or devices such as computer screen readers for employees with visual impairments, or a specific telephone that is compatible with an employee's hearing aid. Um, this does not include personal assistive devices such as hearing aids or prosthetics. Providing accommodations. An employer generally does not have to provide a reasonable accommodation unless an individual with a disability has asked for one. Once a request is made, the employer must engage in an interactive process. So when selecting an accommodation, where more than one accommodation would work, an employer may choose the one that is less costly or that is easier to provide. Many years ago, I had a director who used the phrase, you can ask for the Cadillac, but you may get the Kia. So you can aim high in your requests, but be prepared for the possibility of getting something more standard, as long as it assists you to do the task that is needed or required. Remember that the interactive process is fluid, and if an agreed upon accommodation doesn't work for you, you should go back and start the discussion again with your employer. The Job Accommodation Network provides some really good resources and ideas on their website for accommodations as well. Undue hardship. An employer is required to make a reasonable accommodation to the known disability of a qualified applicant or employee, as long as it does not impose an undue hardship on the operation of the employer's business. An accommodation may impose an undue hardship if it requires significant difficulty or expense when considered in light of factors such as the employer's size, financial resources, and the nature and structure of its operation. So keep in mind that if you work in an office with only 5 people and there is more than one office, the company financials would be based on the whole company, not just the one office. So that could change an employer's ability to state that an accommodation would cause a financial hardship. An employer is not required to lower quality or production standards to make an accommodation. Employees are expected to perform the essential functions of the job with or without reasonable accommodations. The cost of providing an accommodation is often misunderstood and misrepresented. Various studies have found that reasonable accommodations cost much less than many employers expect. Can we please bring up poll number 2? Okay, great. So poll number 2, when should I disclose my disability to my employer? The first option is during the application process. The second option is when I am hired. And the third option is when I feel I need an accommodation. So if you can please answer that question. Okay, do we have enough answers in order to see the results? Okay, great. All right, so we have about 33% said during the application process, 13% said when I am hired, and 53% said when I feel I need an accommodation. Okay, great. So what I tell my clients is that you do not have to divulge that you have a disability unless you need an accommodation. So when you feel that you will need an accommodation, whether it's at the interviewing process, while you're applying, while you're going through the interviews, while you're starting the job, whenever you feel you might need that accommodation, is when you would request it. Okay. So there it is. A request for a workplace adjustment qualifies as a request for reasonable accommodation if the change is requested for a reason related to his or her disability. So at whatever point you feel that you're not able to fully participate in the process is when you ask for that accommodation. Okay, so to request an accommodation, employees do not need to use medical terminology or explain their disability or condition. They can just use plain English. Um, an employee may ask for a workplace adjustment without specifically referring to the Americans with Disabilities Act or the ADA, or using the words accommodation or reasonable accommodation. They should specify that the request is related to a disability, and somebody can do that request for you. So if you have a medical professional that can assist with that, a vocational rehabilitation counselor, a job coach, or even staff at Disability Rights Florida, I've helped many people request accommodations. You will need to provide enough information to show that you have a disability covered by the ADA and that the requested accommodation is needed for you to perform the job. Many times what I tell people is to have a copy of their job description so that you can see what is an essential function, and whatever accommodation is needed to perform that essential function is what should be documented. And to have a physician help write that is very helpful. Following an accommodation request, the employer and the individual should engage in the interactive process to identify the appropriate reasonable accommodation. Okay, can we please bring up slide number 3? Okay, so the question is, did you ever engage in the interactive process with your employer? The first response is yes. The second response is no. And the third is, what is an interactive process? Okay, is that enough time? Do we get enough responses? Okay, so we had 49% say yes, they have engaged in the interactive process with their employer. 34% said no, they have not, and 17% said, what is an interactive process? Okay, so we're going to talk about that next. Thank you. So the Americans with Disabilities Act, or ADA, requires covered employees to provide effective, reasonable accommodations for employees with disabilities. To help determine effective accommodations, the Equal Employment Opportunity Commission, or EEOC, recommends that the employers use an interactive process, which simply means that employers and employees with disabilities who request accommodations work together to come up with the accommodations. A covered employee under the ADA is generally one with 15 or more employees. Some state and local laws may require that employers with fewer employees provide reasonable accommodations. And again, keep in mind that if you have work in a small office, it may be a larger company or a parent company that has a lot more than 15 people. So they would be required to, work with you on that interactive process. According to the EEOC, the interactive process is not always required under the ADA. So in many instances, the appropriate accommodation is obvious and therefore is not necessary to go through a step-by-step process. For example, if an employee who uses a wheelchair, again, the same example, requests that the desk be placed on blocks to elevate the desktop above the arms of the wheelchair, and the employer complies with that, then there really doesn't need to be an entire, I'm sorry, I lost my spot here. Okay, there we go. Then everything that's needed has been identified, and there really isn't a need for a formal process. I do want to add, however, that I've had many clients come to me that had unwritten accommodations in place, but when management changes, that they lost their accommodation. So I do recommend putting all requests in writing. So even if your employer, your manager, your supervisor says, sure, no problem, let's do this, you may want to follow up and have it in writing so you have it for the future. When an accommodation is not obvious, an appropriate accommodation is best determined through a flexible, interactive process. As part of this process, the EEOC recommends that employers analyze the particular job involved and determine its purpose and essential functions. The employer should be consulting with the individual with the disability to ascertain the precise job-related limitations imposed by the individual's disability and how those limitations could be overcome with a reasonable accommodation. They should be in consultation with the individual to be accommodated, identify potential accommodations, and assess the effectiveness each would have in enabling the individual to perform the essential functions of the position, and consider the preference of the individual to be accommodated, and select and implement the accommodation that is most appropriate for both the employee and the employer. And that is in an ideal world. It doesn't always work that way, but that's how it should be. If a manager or direct supervisor receives an accommodation request, he or she should refer the employee to HR or another person who is responsible for responding to such requests. The person receiving the accommodations request may ask questions that will let him or her make an informed decision about how to meet the request, including what type of accommodation is the employee requesting? What is the nature of the employee's disability or functional limitation? If we can please bring up the next poll, please. Okay, I believe this might be our last poll. Thanks for sticking it out with me here. The question asks, how long does my employer have to determine if my accommodation request was reasonable? The first answer is 7 days. The second answer is 30 days. And the last answer is there is no time limit. So what do you think is correct? Okay, do we have enough answers to share? Okay, great. So 18% said 7 days, 61% said 30 days, and 21% said there is no time limit. Um, and that is right. There is nothing mandated. There is not a time frame mandated for the response from your employer. Okay, if we can close that poll, please. Thank you. So, what the last I wanted to share was that there is no law, there is no policy that states that the accommodation request must be reviewed and decided within a time frame. It just says within a reasonable time frame. So keep that in mind. Okay, so as part of the interactive process, we would like for employers to do further research on the ADA and reasonable accommodations, determine whether the employee's condition is covered under the ADA. We would love for employers to contact the Job Accommodation Network or JAN for guidance on the types of accommodations that might best meet the needs of the employee and the organization, and then refer the employee to the appropriate person within the organization if there is a designated individual who handles accommodations requests, and then follow up with both to ensure the request is adequately addressed. So yeah, like I mentioned, there are no specific policies or procedures that employers must follow when trying to accommodate an employee with a disability, but requests must be made within a reasonable time. It's also advisable to communicate with employees regarding progress made in providing an accommodation, especially if it may take some time. So, um, it's great for the employee to be able to suggest the type of accommodations that may be most effective to ensure their productivity. The employee knows best. The person with the disability knows best as to what might help them. And if they don't know, then have the conversation and work through it. Um, So some employers do opt to establish formal accommodations policies and procedures and to centralize this function. There are benefits to this, increased likelihood that accommodation requests will be handled properly and consistently, improved documentation of an employer's efforts to comply with the ADA, and improved understanding among employees about what to expect if they request an accommodation. An employee who already provided documentation of their disability should not have to provide new medical records for the same disability. Um, so that was the substantive part of this. How can Disability Rights Florida help you? So all of our services are free and confidential. We have a wide range of priorities. We have various services. Um, you can contact Disability Rights Florida for assistance if you need it going through the interactive process. Um, a lot of our callers receive information and referral, short-term assistance, self-advocacy support, technical assistance. Some people do get investigations, dispute resolution support, negotiation and mediation support, advocacy services, and at sometimes legal representation. Funding disclaimer, this presentation was produced at U.S. taxpayer expense through a grant from the Social Security Administration. While Social Security reviewed this communication for technical accuracy, it is not an official Social Security communication. If you have any questions about this presentation, you can please feel free to contact us at Disability Rights Florida. Our mailing address is 2473 Care Drive, Suite 200 in Tallahassee, Florida, 32308. Our phone number is 1-800-342-0823. Our TDD is 1-800-346-4127. And our website is www.disabilityrightsflorida.org. And this is our feedback survey to tell us how we did. You can scan the QR code or visit the link, and there's a presentation code as well, ZM6.
All right. Thank you, Allison. We appreciate all the information that you provided to us, and stay on because we're going to go through some questions in just a couple of minutes. As Allison said, there is a QR code on the screen. It'll take you to a short survey asking for your opinion of the content presented today. We would greatly appreciate it if you could take a few minutes to give us your feedback so that we can continue to improve the programs that we offer. There's also a link to the survey in the chat if you prefer not to use a QR code. You can scan the QR code or click the link and wait until after the question and answer session to complete this if you'd like. So we have quite a bit of time left here in our sessions. As a reminder, if you have a question, please post it using the Q&A button at the bottom of your screen. Please try to limit personal information about yourself so that we can maintain your privacy. We can only answer basic questions here. If you have a specific complex situation that you need assistance with, I encourage you to go to our website and click the help and contact button and fill out an intake form so that we can address your issue more comprehensively and privately. So let's go to the first question, and bear with me too, because each time somebody adds a question, the questions move. So sometimes as I'm reading them, they'll move. But anyway, let's go with our first question, which is the information that you're sharing today specific to Florida, or does it apply to other states? And Allison, go ahead and
Yeah. So that's a great question. So certain things do change from state to state, like the size of the business in order to request accommodation. So always check within your own state as well.
okay, great. And does this apply to schools like a cosmetology school?
So this presentation is about reasonable accommodations in the workplace. So it's different if you're requesting accommodations for a school. Keep in mind that Disability Rights Florida does also assist with those types of accommodations that are needed.
Great. Okay, thank you. All right. How can we access external support when the employer is not participating well? They don't seem to be taking me seriously, and I'd like someone else to back me up. So I guess they're asking, is there an
Hmm.
alternate person that they could go to?
Sure. So there are options. So if you're denied an accommodation or just not getting the runaround, Um, the first thing that's important to understand is why a request was denied. So I suggest asking your employer to put the denial in writing with an explanation of why it was unreasonable or how it was an undue burden. So here at Disability Rights Florida, we investigate these types of cases by reviewing your documentation, including things like your physician's letter explaining the accommodations needed, and compare what you're asking for to the requirements of that specific role in your organization. So many times I see that my client didn't share the supportive documentation that explains why the accommodation is needed. Your company may have, an appeal option as well if you've been denied. So you can reach out to us. You can reach out to agencies such as the EEOC, the Equal Employment Opportunity Commission, and FCHR, which is the Florida Commission on Human Relations. They can do these types of investigations. Keep in mind that they can take a long time through EEOC and FCHR. I currently have two cases that we filed on behalf of a client around September of 2023 that finally one of them seems to have some movement. So if these entities investigate and determine that the accommodation requested was reasonable, then they would provide you with a right to sue letter. Then you would need to possibly hire an attorney to assist you with a lawsuit. So you do have options. And we are here at Disability Rights Florida to assist you with that.
Great, thank you, thank you. The next question, I think I can answer this one. Do other states have the equivalent of disability rights, Florida, and how do we find them? So yes, we are part of a national network called the National Disability Rights Network, NDRN, and they have a website, and it's ndrn.org. And they have a section on their website where you can type in the state and it'll bring up a website for that particular state. There is a disability rights type organization or protection advocacy organization in every US state and territory. So you should be able to find one if you're not located in Florida. So I don't see any other questions. I'll give it just maybe one more minute for, oh, I think one just popped in. Yes, it did. Okay, let's see. I asked for an accommodation after I asked for an accommodation after receiving a hire letter. After asking for an accommodation, my hire letter was revoked. Do you think it's better to ask for an accommodation after the first day on the job? Is there more protections once starting a job?
So, again, you should be asking for the accommodation as soon as you know that one is needed. And I would suggest maybe if you want to call our intake department, maybe we can talk a little further about that. Keep in mind that all of our services are free. And if we are not able to assist you, we may be able to give you some really good resources to take with you.
Okay, very good. I don't have any other questions in our Q&A. I will give it another couple of seconds here, but I just want to say that we appreciate all of you joining us today. And since we're not seeing any other questions here, I will say that this concludes our webinar for today. The webinar and the PowerPoint slides will be available on our website in about a week. So thank you for joining us, everyone, and have a wonderful day.
Thank you.